Welcome to HK Immigration News. Feel free to contact us if you have any queries. Subscribe this channel for latest embassies and US immigration news. Now let's continue with today's topic. On the 20th of July, 2026, the U.S. Department of Homeland Security (DHS) issued a final rule rescinding the 2022 Public Charge Regulation, and restored broad discretion for officers to weigh all pertinent factors when assessing whether an applicant is likely at any time to become a public charge. Limited the benefits and factors that immigration officers could consider in public charge determinations. As part of the immigration process, the rule will take effect the 18th of September, 2026. An applicant for a visa, admission, or adjustment of status is inadmissible if, in the reviewing officer's opinion, the individual is likely at any time to become a public charge. This ground of inadmissibility reflects the long-standing policy that non-citizens should be self-reliant rather than dependent on public benefits. Under the new policy, USCIS officers will have broader discretion to determine whether an applicant is likely to become a public charge. They may consider factors such as income and financial resources, age, health, education and job skills, family situation, the applicant's overall ability to support themselves financially. Under U.S. immigration law, some people applying for an immigrant visa, such as immediate and family petitions, adjustment of status Form I-485, many employment-based immigrant visas or admission to the United States, can be denied if the government believes they are likely to become primarily dependent on government assistance in the future. The 2022 rule gave immigration officers more limited guidance about what they could consider. After the 18th of September, 2026, USCIS officers will once again have broader discretion when deciding whether someone is likely to become a public charge. Instead of relying on a narrow list, officers can evaluate the totality of the applicant's circumstances, including age, health, family size, income, assets and savings, debts and liabilities, employment, education, job skills, future earning potential, affidavit of support, any other relevant evidence showing whether the applicant can support themselves financially. Employment-based immigrants may also be subject to the public charge ground if it applies to their application. However, having a legitimate job offer and employer sponsorship can be favorable evidence because it supports the applicant's financial self-sufficiency. For applicants, the new rule means they should focus on proving they are financially self-sufficient, and are unlikely to depend on government assistance. USCIS and consular officers will have broader discretion to evaluate the totality of the circumstances. Here are the most important things applicants should pay attention. Family-based immigrants should ensure the petitioner or joint sponsor clearly meets the income requirements for Form I-864. Tax returns, W-2s, employment letters, and pay stubs should be complete and up to date. If the applicant has work experience, vocational training, or higher education, they should document it. Having employable skills can help show future financial independence. Degrees, diplomas, certifications, and professional licenses may support the case by showing earning potential. Applicants should complete the required immigration medical examination. If an applicant has a medical condition that could affect their ability to work, evidence that treatment is available or that financial support exists may become more important. Savings, property, investments, or other financial resources may strengthen a case, especially if income alone is limited.